Take it away.
Number one, you deserve a Purple Heart for being here all day.
Thank you.
So really, I've enjoyed working with you and your team regarding Ukraine oligarch seizures, and I want to compliment you. Y'all have done a really good job of going after oligarchs, and hopefully we can seize some of their assets and send it to the Ukrainian people. And I want to help work with you as much as we can, create some international tribunal to let Putin and his cronies know you're going to pay a price here. There's no forgiving and forgetting in this war. You picked a fight, you picked the wrong fight, and they need to pay a price. Do you agree with that?
I do.
Okay. Now, some areas of disagreement. There are 4 states, Arkansas, Mississippi, South Dakota, and Utah, and more are coming, that have enacted legislation that regulates certain medical and surgical interventions on minor children, 21, 18, whatever the state is, regarding transgender surgeries and puberty blocking medical procedures. Your office wrote a letter March 31st, 2022 to states suggesting that if a state passed a law saying, you know, banning medical procedures to transition minor children, that they may be running afoul, the state may be running afoul of the equal protection or due process clause of the 14th Amendment. Is that your position?
So the department believes that all people in the United States are entitled to be treated with dignity and respect, that the situation that you're talking about has to be evaluated by doctors, by families,
Well, I mean,
by the individuals. They have to make those determinations.
But states have passed laws, okay? We have 50 states here. They have passed laws, and more are coming, prohibiting this procedure because the state in question believes that allowing transition medical procedures on a minor is a life-altering event, and it shouldn't be done until you're older, so you really better appreciate what you're doing. States have taken that view, and I think more of them will take that view. Is it the position of the Department of Justice that such laws are unconstitutional?
The position is that categorical across the board prohibitions on certain kinds of surgeries and not others have to be evaluated on a case-by-case basis, and the Civil Rights Division will do that with respect to each of the laws that you're talking about when the time comes.
Okay, so the bottom line is the 4 laws in question. Have you looked at the laws in Arkansas, Mississippi, South Dakota, and Utah?
I haven't. I don't know whether the Civil Rights Division has.
And just look at them and get back to me and answer my question, are they constitutional in the eyes of the Department of Justice? Thank you. I did it in 3 minutes.
I appreciate there's a second round of 3 minutes, which will be strictly enforced. You'll hear the gavel at 3 minutes. I'm going to wait and save my questions to the very last. And so I begin this round of questions, the second round of questioning. Senator Whitehouse.
Thanks, Chairman, and thank you again, Attorney General. I'm going to go to a topic that was addressed earlier by Senator Blumenthal and Senator Graham, and that is the question of the freezing, seizing, and forfeiture of Russian oligarch and kleptocrat assets. One of the problems that we are running into is that for the highly valuable assets that can be seized from the Russian oligarchs, like massive yachts or Fabergé eggs or other works of very expensive art, the value is well above $500,000. And right now we have an administrative forfeiture procedure that applies for assets that are valued only up to $500,000. Above that, you have to go through a different procedure. The nutshell way that I think about this is that the simpler administrative forfeiture procedure allows the government to proceed in rem against the asset. And people have to show up if they have a claim to the asset. It's a little bit like what the Department of Justice did with botnets. They had a proceeding in rem against the botnet, and anyone who laid claim to that botnet and asserted a right not to have it taken down, they were welcome to show up in court and present themselves. They probably would have gone off in handcuffs, but they certainly had that right. With respect to the assets above $500,000 that are associated with the Russian oligarchs who are associated with the really criminal war that Putin has launched into Ukraine, we would like to see the law changed. Senator Graham supports this. Senator Blumenthal and I support this. We have legislation to support this. And I just wanted to take my moment here with you to make sure that you and I, the Marshal Service, your forfeiture offices, are all properly aligned so that we can move quickly to get this changed. At the moment, having to identify the owner of an asset, which is often hidden in Russian nesting doll layers of faraway bank accounts, shell corporations, Cyprus holding companies, really puts a major crimp in our ability to proceed fairly. And I don't think there's any national interest or public interest in having Russian oligarchs who've supported this war treated better than American citizens simply because their assets are more valuable. So would you please tell your team to greenlight working with us to get this bill passed quickly out of this committee and into legislation on the floor?
As you can imagine, I'm wholeheartedly in favor of the team working with you on this. As you know, we recently, thanks to the work of the Congress, I was able to certify for transfer to Ukraine the money that was seized from one oligarch, Malofeyev, and most recently, our task force klepto capture succeeded in forfeiting $75 million from Victor Vekselberg. They have done an enormous amount of work to find nesting within nesting within nesting of shell corporations. It would be easier if that weren't required. So we'd be happy to work with your team on this. Yeah,
Thank you very much. Thank you, Chairman.
Thank you, Senator. Thank you, Senator Whitehouse. Senator Grassley.
Thank you, Mr. Chairman.
Senator Blumenthal.
Thanks, Mr. Chairman. Thank you again, Mr. Attorney General. I want to thank you for the supportive comments you've made about the Open Apps Market Act. As you know, I'm hoping that the Department of Justice will support us because right now we have a duopoly in the mobile apps stores, Apple, Google, and this measure would stop those two companies from exacting rents and boxing out competitors. I'm hoping that the Department of Justice will support this measure.
Well, as I said, Senator Assistant Attorney General Cantor has already testified in support of the bill, so we hope to be able to get the administration on board as well, but he has already, and that represents my views as well.
Thank you. I want to talk about the Foreign Intelligence Surveillance Act,
Yeah.
specifically Section 702. Not exactly the topic of major inquiry here, but enormously important.
Yeah.
And without going into any classified information, that provision, I believe, was instrumental in preventing major catastrophic aggression against our nation and also helping our allies like the Ukrainians with intelligence that was extremely critical to pushing back the Russians and knowing what they needed to know on the battlefield. Could you comment on the importance of reauthorizing Section 702?
Yes, Senator, this is a statute that I was, we didn't have the last time I was at the Justice Department, so I really didn't know what to expect when I came in this time. I will tell you that every morning I have a all threats briefing with the FBI, with an intelligence community briefer, with our National Security Division. An enormously large percentage of the threats information that we're receiving comes from 702 collection. All the examples that you're talking about, Ukraine, threats by foreign terrorist organizations, threats coming in from adversaries from China, from North Korea, from Iran, from Russia, a lot of what we do in the area of cyber, and particularly in ransomware investigations, of finding out who is behind the ransomware investigation, and sometimes of obtaining the keys, comes from information that is at least part fed by Section 702. We would be intentionally blinding ourselves to extraordinary danger, in my view. And this is not a view that I jumped on, I've always held. This is something I've learned as I've been at the department.
And blinding our allies as well. Thank you.
After Senator Lee asks, we're going to take a brief intermission. Senator Lee?
Thank you, Attorney General Garland. I want to echo briefly what Senator Klobuchar described. I hope you'll look at our letter and investigate thoroughly those issues. As you know, I've long respected you, and I've long respected your department. I have become concerned recently that notwithstanding the great men and women who serve and have served for generations in the Department of Justice, there are some things that lead me to wonder whether some actions are being politicized within the department. One example of this relates to 18 U.S.C. Section 1507. Ever since the leak of the Dobbs opinion and then the issuance of the Dobbs opinion by the Supreme Court last summer, we've had protesters who have been showing up at the homes of Supreme Court justices, carrying signs, picketing, shouting. It's very clear that they're trying to influence, in one way or another, those serving on the United States Supreme Court, trying to influence jurisprudence. And yet, not one person, to my knowledge, has been prosecuted for such things under 18 U.S.C. Section 1507. About 2 weeks ago, this committee invited some officials from the Department of Justice to brief committee staff on protests at the justices' homes and ask about any arrests that have been made or might be made for people engaged in that behavior. The briefers came to the briefing and informed staff that they hadn't read Section 1507. I assume you've read it, of course. Just wondering why the department would schedule such a briefing on a statute without having read it, and especially why no actions have been brought under Section 1507 for these actions. I've got a lot to cover. Can you answer that?
I'll try to answer all these questions together.
Just tell me, am I right in concluding that you haven't brought any charges under 1507?
So I don't know the answer to that. We have the thing that mattered, and as soon as the Dobbs draft leaked, I ordered the marshals to do something that the United States Marshals had never in history done before, which was protect the justices' homes, residence, and lives 24/7. No Attorney General had ever ordered that before, and no Justice Department had ever done that before.
Which is terrific. That's fantastic.
So I'm getting to the why. So we sent more than 70 U.S. Marshals for this purpose. Those marshals' priority is protection of the lives of the justices and their families. They are on site, but their priority job is protection. That is why when someone did come to assault Justice Kavanaugh, he had to go away from where they were because there were two marshals in front of the house, and eventually he self-reported himself. The marshals have been advised, and they know, the marshals on the ground, they have full authority to arrest people under any federal statute, including that federal statute. But they have to make the determination on the ground whether they can do that in a manner that is safe and able to protect their main mission. Now, there are also state and local entities which have similar authorities, and which I understand the Supreme Court Marshal has asked them to do this as well. I don't know whether they have done any of those things.
Okay, thank you. I'd love to follow up with you more on that later. It is concerning to me when you show up at the home of a public official, you're sending the message of implicit violence. You're sending the message, we know where you sleep. We know where you and your family are most vulnerable, and it's very concerning to me. That's the concern that I've got, is that you don't seem to condemn the divisiveness if it's on the left. I want to go back briefly to the text of Section 1507. Section 1507 is pretty darn clear. I personally don't see how anyone could protest outside the home of a Supreme Court justice, especially while engaging in issue advocacy related to a case that they've taken or are currently hearing, it doesn't violate 18 U.S.C. Section 1507. So the fact that you've put U.S. Marshal Service in charge of protecting their homes, great. The fact that not a single arrest has been made, not a single set of charges have been made, is very disconcerting, as is the fact that even if the marshals don't choose to make an arrest there, which is stunning to me that they haven't, but even if they hadn't, there's video footage. You can identify folks. You've proven your ability to do that, and the fact that you're not bringing that is deeply disturbing to me, as it was when, on the day of the Dobbs decision, the Department of Justice took what I believe was a pretty unprecedented step of issuing a scathing statement, not just saying we disagree or we're disappointed with the outcome, but making arguments that I believe called into question the legitimacy of the court. I have never seen the Department of Justice do that. It is cause for additional concern when I see people like Philip Formes, having received clemency, is now having to face the prospect of being prosecuted again after having received clemency by a prior president. Add all this up with the fact that by the end of this year, we're going to see the expiration of Section 702 of the Foreign Intelligence Surveillance Act. The department's already asking and chomping at the bit to be asking us to simply reauthorize that, notwithstanding the fact that there are all kinds of examples of how this has been politicized, how Section 702 has been misused. The current standard for a warrantless backdoor search of the content of communications of American persons is reasonably likely to return evidence of a crime. But the ODNI's recently declassified semi-annual report, released on December 21st of 2022, reports all kinds of non-compliant searches. These are just the ones we know about, just the ones that the ODNI report was able to identify, involving U.S. persons, including the searches of prospective FBI employees, members of a political party, individuals recommended to participate in the FBI Citizens Academy, journalists, and even a congressman. The politicization of the department is a problem. And you can tell your department, not a chance in hell we're going to be reauthorizing that thing without some major, major reforms. Your department is not trusted because it has been politicized. I know you are a good person. You have the ability to rein it in. I ask that you do so promptly.
Thank you. Thank you, Senator Lee. Senator Cruz.
Thank you, Mr. Chairman. General Garland, the Department of Justice should enforce the law regardless of politics. I do not believe that has been what is happening the last 2 years. Among other things, I believe you very much want to indict Donald J. Trump. Toward that end, the Department of Justice has leaked that DOJ is investigating and intends to indict Hunter Biden. The purpose of those leaks, I believe, was to set the predicate for an indictment of Trump, to say, look how even-handed we are. We're indicting a Biden, we're indicting a Trump. Those leaks are not law or enforcing the law, they are politics. Did you know about the leaks about the Hunter Biden investigation?
I don't know about the leak that you're talking about, I'm not. Leaks are in violation of our regulations and our requirements. So the answer is
the leaks are consistently on one side of the aisle advancing one political agenda. As you know, the FBI raided Donald Trump's Mar-a-Lago home. And subsequent to that raid, there have been multiple leaks about what was discovered there, including a photograph of documents that were discovered there. Did you know about the leaks from that raid?
The photograph was a filing in court in response to a motion filed by Mr. Trump. It was not a leak.
So you're testifying there haven't been leaks about the Trump raid investigation?
I'm responding to the point about
Do
the
you know about the leaks that have occurred
I've
concerning
read
Trump?
the leaks. They are inappropriate. We also don't know where they come from. Witnesses on the,
But what's interesting is when the shoe was on the other foot, I believe your intention, and I believe it's a political intention to indict President Trump, became infinitely harder when classified documents were discovered repeatedly at President Biden's multiple residences. According to the public record, those were first discovered on November 2nd, 6 days before the prior election. Department of Justice was notified on November 4th, and yet miraculously there was no leak about the classified documents at President Biden's home when it politically benefited the effort to go after and charge Donald Trump. DOJ leaked. When it potentially harmed the Democrat president, DOJ did not leak. Does that strike you as at all a double standard?
leaks under all circumstances are inappropriate, and they were not directed by anyone in the Justice Department.
Let me say in particular on Hunter Biden, I very much hope that an investigation of Hunter Biden is focused not just on his own personal substance abuse issues, but on connections to his father and potential corruption. That is the matter of public concern and why people are concerned. And it was striking that the leak that came out from DOJ suggested this is just going after some poor person struggling with drugs instead of looking at the very real evidence of corruption. Will you commit that the investigation will actually examine the public corruption aspect and not simply scapegoat Hunter Biden as an individual?
I can't comment about the investigation other than to say that all the matters involving Mr. Hunter Biden are in the purview of the U.S. Attorney in Delaware. It's not restricted in his investigation in any way.
Well, you don't comment here, but then you leak at the same time.
Senator Hawley? Oh, just to alert the members, and Senator Cruz is next.
Thank you, Mr. Chairman. General, welcome.
Thank you.
As you know, as I observed at your confirmation hearing, you had built a long record on the Federal Court of Appeals and a reputation of being relatively nonpartisan. And so I had hopes that your tenure as Attorney General would continue that record. I have to say I'm deeply disappointed in what the last 2 years have shown. In my judgment, the Department of Justice has been politicized to the greatest extent I've ever seen in this country. And it has done a discredit to the Department of Justice, to the FBI, and to the administration of law in this country. Let me start with a simple question. General Garland, is it a federal crime to protest outside of a judge's home with the intent of influencing that judge as to a pending case?
The answer to that is yes, but I also want to at least respond to your characterization of the department, which I vigorously disagree with. I believe the men and women of the department pursue their work every single day in a nonpartisan and an appropriate
General
way.
Garland, there are thousands of men and women who do that, and I'll tell you, I hear from prosecutors at the Department of Justice, I hear from agents at the FBI who are angry that it is treated as the enforcement arm for the DNC instead of upholding the law in a fair and even-handed manner. So you are right, there are thousands of men and women that are doing the job, but it is the political leadership that you're responsible for. So you just said, yes, it's a crime to protest at the home of a judge. Same goes for jurors, by the way, with the intent of influencing a case. But in the wake of the leak of the Dobbs decision, when rioters descended on the homes of 6 Supreme Court justices, night after night after night, you did nothing. The department did nothing. When extremist groups like Ruth Sent Us and Jane's Revenge openly organized campaigns of harassment at the homes of justices, you sat on your hands. When these same groups posted online information about where the justices worship, or their home addresses, or where their kids went to school, you again sat on your hands and did nothing. Your failure to act to protect the safety of the justices and their families was an obvious product of political bias. You agree with Roe versus Wade, you disagree with the Dobbs decision, And the Department of Justice under this president was perfectly happy to refuse to enforce the law and allow threats of violence. And as you know, those threats finally materialized with Nicholas Roski, a 26-year-old man from California who traveled across the country, was arrested outside the home of Justice Kavanaugh, armed with a handgun, a knife, and burglary tools. And he said he came there to kill Justice Kavanaugh because he was enraged by the leaked opinion. Now, of course, you're prosecuting that individual for attempted murder, but did you bring even a single case to enforce this law, or did the Department of Justice decide this law doesn't apply if it's harassing justices for an opinion we don't like?
When the Dobbs draft was leaked, I did something no Attorney General in the history of the department had ever done before. For the first time in history, I ordered United States Marshals 24/7 to defend every residence of every justice.
General Garland, as a judge, you're familiar with asking counsel to answer a question.
I am answering.
Has the Department of Justice enforced this statute? Have you brought a single case against any of these protesters threatening the justices under 18 U.S.C. Section 1507? Have you brought even one?
Senator, you asked me whether I sat on my hands, and quite the opposite. I sent 70 United States Marshals.
Let me try again.
To defend.
Has the Department of Justice brought even a single case under this statute? It's a yes/no question. It's not a give a speech on the other things you did.
The job of the United States Marshals is to defend the lives of
the answer is no.
Is to defend the lives of the justices, and that's their number one priority. They have.
Why are you unwilling to say no? The answer is no. You know it's no. I know it's no. Everyone in this hearing room knows it's no. You're not willing to answer a question. Have you brought a case under this statute? Yes or no?
As far as I know, we haven't, and what we have done is defended the lives of the justices with over 70 U.S. Marshals.
How do you decide which criminal statutes the DOJ enforces and which one it doesn't?
The United States Marshals know that they have full authority.
I recognize you want to give a separate speech.
No, I don't want to give
How do you decide which statutes you enforce and which ones you don't?
The Marshals on scene make that determination in light of the priority of defense.
The Marshals do not make a determination over whether to prosecute. You, the Attorney General, make a determination, and you spent 20 years as a judge, and you're perfectly content with justices being afraid for their children's lives, and you did nothing to prosecute it. Let's shift to another area.
Can I answer the question?
No, you cannot. You have refused to answer the question.
I am answering your question. The Attorney General does not decide whether to arrest.
How did you choose not to enforce this statute?
The Marshals on scene.
Marshals don't make that decision.
They do make the decision of whether to make an arrest.
Prosecute someone? No, they don't.
If they make
Marshals do not have prosecution.
If they make an arrest, then it goes to the Marshals.
Let's change topics because our time is limited. We've also seen across the country violent attacks at pregnancy centers by similar left-wing terrorist groups, including one graffiti of a firebomb building said, "Jane was here." There have been attacks all over the country. And yet, the Department of Justice has not brought these violent criminals to justice. You contrast that. If you're a violent criminal and you attack a crisis pregnancy center, that is not a priority in the Biden Department of Justice. Contrast that to Mark Houck, who's a pro-life activist. He's a sidewalk counselor. And he had an altercation with someone who allegedly interfered with his son's personal space and threatened his son, and he pushed him. Now, in an ordinary world, pushing someone would be maybe a simple misdemeanor assault, but not under the Biden Department of Justice. If you're a pro-life activist, what can you expect? Well, in this instance, according to Mr. Houck's wife, 24 agents clad in body armor and ballistic helmets and shields and a battering ram showed up at his house pointing rifles at his family. Why do you send 24 agents in body armor to arrest a sidewalk counselor who happens to be pro-life, but you don't devote resources to prosecute people who are violently firebombing crisis pregnancy
It is a
centers.
priority of the department to prosecute and investigate and find the people who are doing those fire bombings. They are doing it at night and in secret. So, and we have found one group which we did prosecute.
You found one. How many have there been? How many attacks?
There have been a lot, and if you have any information specifically as to who those people are, we
Let me
would
ask
be
you
glad.
something.
We would be glad to have
Did you personally
that.
authorize 20 agents going to Mr. Houck's house? And he offered to turn himself in through counsel, but you didn't want that. The Department of Justice wanted to make a show of it. Did you personally authorize it? And do you want to apologize to Mrs. Houck and her 7 children for being terrorized?
The decisions about how to do that are made at the level of the FBI agents on scene.
Did you know about it?
I did not know about it until the way you're describing it, and my understanding is the FBI disagrees with that description.
Was it a mistake?
Senator's time has expired. I'm going to allow the witness to respond to any of the questions that were asked.
Was it a mistake?
I'm going to chair the committee, Senator. I'm sorry you're not.
You said you'd allow him to respond. I repeated the question I asked, which is, was it a mistake to send 20 agents to arrest him at the crack of dawn?
You had your time and more
You just
than
said
any-
you're going to allow him to respond. You just said, I'm going to allow him to respond to the question, so I repeated the question. Was it a mistake?
You
That
asked
was the pending
questions you want to
question.
ask. I'll ask the questions I want.
That's the question I had already asked.
Well,
You just said you'd let him respond.
I'm going to let him respond right
Good.
now. Please don't interrupt him. Thank you.
The decisions about how to do tactical arrests are made by the FBI agents in the field. The FBI has publicly stated that it disagrees with the description you gave of what happened in that example. That's the best I can answer.
At this point, we're going to.
Thank you, Mr. Chairman. Thank you, General, for being here. Good afternoon.
Thank you.
I read this somewhere. I don't remember who said it, but I wrote it, but I remember it. It was once observed that a parent who stops loving their children, if a parent stops loving their children, the children will not stop loving the parent. The children will stop loving themselves. I know we can agree that we should encourage parents to be involved in their kids' lives.
Absolutely.
And I'm sure we can agree that we should encourage parents to make their kids do their homework.
Yes, although there's sometimes some resistance to that.
Right, right. And to make sure they get sleep at night so they can be ready for school.
Yes.
Here's what I've always been confused about. Didn't you understand the chilling effect that it would have to parents when you issued your directive, when you directed your criminal divisions and your counterterrorism divisions to investigate parents who were angry at school boards and administrators during COVID?
So, Senator, if you just give me a moment to put the full context, I did not do that. I did not issue any memorandum directing the investigation of parents who were concerned about their children. Quite to the contrary, the memorandum that you're talking about says at the very beginning of the memorandum that vigorous public debate is protected by the First Amendment. And the kind of concerns that you're talking about are, as expressed by parents, are of course completely protected. The memorandum was aimed at violence and threats of violence against a whole host of school personnel. It was not aimed at parents making complaints to their school board. And it came in the context of a whole series of other kinds of violent threats and violence against other public officials.
Let's walk through this. Your directive to your criminal division and your counterterrorism division came in a response to a letter from the National School Boards Association, did it not?
In part to the letter and in part to news reports of violence and threats of violence.
And the National School Board Association said these parents ought to be investigated under the Patriot Act as potential domestic terrorists.
And you'll notice, Senator, that I said nothing like
I
that.
understand, but that's what the letter said.
There was a reference to that in the letter,
Right.
something I disagree with.
And your employees helped them write the letter, didn't they?
I don't know anything to suggest that that's true.
I
No,
think
don't.
it is true.
Well,
And the White House helped them write that letter, didn't they?
I don't know. I have no knowledge about that, but certainly I don't know anything about my employees
And so-
helping write that letter.
So you get this letter from the National School Board Association asking you to investigate parents that your employees helped write and that the White House helped write, and you issue a directive to your criminal division and to your counterintelligence or counterterrorism division to start investigating parents who are angry. What did you think was going to happen?
Say again, Senator, that nothing in my memorandum says to investigate parents who are angry. Quite the opposite. It says that the First Amendment protects that kind of vigorous debate. The only thing we wanted was for an assessment to be made out in the field about whether federal assistance was needed to prevent violence and threats of violence.
Well, one of your field, that's not the way your department implemented your directive. One of your field offices actually opened an investigation. You set up a website and a hotline to report parents. And
I don't think, we didn't set up a specific hotline about this. This was a reference to the FBI's
Democratic
hotline.
Party official contacted you. They said that some Republicans were inciting violence by expressing public displeasure with school districts' vaccine mandates. And one of your field offices opened an investigation, which is a permanent part of their record.
Senator, I don't know anything about the specific thing that you're talking about. They used to say in high school this is going to be on your permanent record. I don't believe there is any such thing with respect to this.
I think there is at the FBI, General, and you and I both know there is. There was a lady a mom in Michigan. She has a special needs kid, and the kid was doing pretty well. And she got upset with her local school board over its closures and virtual learning policies, and she went to the meeting. And she made an intemperate comment. She accused them of being a bunch of Nazis. Why would the FBI open an investigation of her?
Again, I don't know anything about the specifics of the case, but accusing people of being Nazis, while I find bad, is certainly not criminal. It's totally protected by the First Amendment. And I've said that over and over again. This is not the first time we've discussed this.
That's not what your department did.
Well, this is about the third time I'm being asked about the same memorandum, and each time I've said, and I hope that the senators would go ahead and advise their constituents in the same way, that this is not what we do. We are not in any way trying to interfere with parents making complaints about the education of their children.
But don't you understand, General, and I believe you, but don't you understand that this looks like you were just giving in to the teachers' unions and politicizing the disagreement, the honest disagreements? I mean, we only, as a result of some of our school board policies, we only experienced the largest learning loss for our kids in modern history. Don't you think parents had a right to be upset?
Absolutely.
Instead of, you implemented, what's a threat tag?
I didn't implement the threat tag. What you're talking about there is a part of internal FBI operations.
Yeah,
as far as I can...
You directed your folks, though, to open threat tags on these parents and investigate them.
Yeah, I did not direct that. My understanding from testimony by the FBI is that when somebody makes a complaint and it involves, if somebody gives a tip that a school official is being threatened, then there's, in order to look at trends. They mark it as a tip involving a school official. They have the same set of threat tags with respect to a complaint that suggests somebody is making a threat against a Supreme Court justice. These aren't complaints. These are tips of violence or threats of
A
violence.
threat tag on a parent for being concerned at a school board meeting?
It's not on the parent, it's not on whoever, it's on to indicate that a threat was made against, or at least alleged that a threat was made against, a school board member or a school official or a teacher or a school. Some of these turned out to be bomb threats.
Senator Kennedy, we're going to have a second round of questioning on behalf of
I understand.
Chairman Durbin, who has gone to vote. I'm going to call on.
You're blaming it on Durbin, huh? I understand. I apologize for
I
going
take
over.
full
Thank you, General.
responsibility. Senator.
Thank you, Senator Whitehouse. Senator Grassley.
Thank you, Mr. Chairman. Thank you for General Garland for being here. My first question is a follow-up to a line of questioning you had with Senator Cotton. You told this committee that, quote, the executive branch cannot simply decide based on policy disagreements that it will not enforce a law at all, end of quote. Then you released a December 16th, 22 memo instructing prosecutors to disregard the law that establishes sentencing differences between cocaine and cocaine base. Your decision not to enforce the law ended congressional discussions at that particular point for a compromise. If DOJ claims that it will ignore the law by declining to prosecute a law that grew out of a bipartisan compromise forged in this committee, it's hard to see how members can trust the department about following any further bipartisan deals. So I'm going to ask you, would you withdraw your memo so that a meaningful legislative discussion can resume? And if you don't have a agreement with me, why wouldn't you do that?
Yeah, Senator, I want to be clear. We're not in any case saying that we won't enforce the law. In all the examples that we're talking about here, people are being prosecuted for violation of the Controlled Substances Act. It's only a question of what sentence we will seek, and this has been a matter of prosecutorial discretion. We do not in any way limit the judge. We have to honestly tell the judge what the drug was and what the amounts was, but this is goes to the question of what we will charge and seek. But we are charging these people with violations of the Controlled Substances Act.
On another point, the Department of Justice charged Nicolas Maduro with narco-terrorism and drug trafficking offenses, and the Office of Foreign Assets Control sanctioned him. Since then, the Biden administration has released $3 billion in foreign Venezuelan assets and authorized Chevron to drill. Does the Department of Justice still consider Nicolas Maduro a fugitive of U.S. justice? And if so, do you commit to diligently pursue his arrest?
To be honest, Senator, I really don't have any information. I know who Maduro is, obviously, and I know that he was charged. I don't know what his current status is. I'll be happy to look into that for you, though, Senator.
Will you answer in writing?
Of course, of course.
This will have to be my last question. I have strong concerns about competition problems in different areas of the economy. Example, I've conducted oversight and drafted legislation to address abuses in pharmaceutical, agriculture, and high-tech industries. Can you tell us what the antitrust priorities are for the Justice Department under your leadership, and are your resources following that priority?
Yeah, so our priority are both to prevent increased concentration in industries that are already concentrated. Agriculture is a very good example. Pharmaceuticals are another very good example, and therefore to closely look at mergers and to investigate them. And our other priority, and closely related, is exclusionary conduct by dominant firms. And we are doing quite a bit of that kind of work, as referenced by some of the cases we've filed. We're also looking at criminal violations of the price-fixing statute and others. With respect to resources, this is an area where we can always use more resources. We are faced on the opposite side with companies with virtually unlimited resources. I express gratitude for the Senate and the House for the Hart-Scott-Rodino fees bill, merger fees bill, which has given us more money to even up the playing field a little bit.
Senator Blumenthal?
Thanks, Mr. Chair.
Mr. Chairman. Attorney General Garland, let me just ask you, does your department have a problem with anti-Catholic bias?
Our department protects all religions and all ideologies. It does not have any bias against any religion of any kind.
Well, you could have surprised me, because given the resources that you are expending and the apparently intelligence assets that you are deploying against Catholics, it appears, and other people of faith, while simultaneously turning a blind eye while people are executed gang style in the streets of our cities, including in my home state, your answer frankly surprises me. Let's talk about the Mark Houck case, for example. You've been asked about this already today, and frankly, your answers really astound me. This is a case where a Catholic pro-life demonstrator, father, was accused of disorderly conduct in front of an abortion center. The local prosecutor, the Philadelphia district attorney, who is a Democrat, a liberal, very progressive, declined to prosecute. There was a private suit that got dismissed. And then after all of that, your Justice Department sent between 20 and 30 armed agents in the early morning hours to the Houck's private residence to arrest this guy after he had offered to turn himself in voluntarily. Here's the photo. Once again, you can see the long guns, you can see the ballistic shields, you can see that they're wearing bulletproof vests. Why did the Justice Department do this? Why did you send 20 to 30 SWAT-style agents and a SWAT-style team to this guy's house when everybody else had declined to prosecute and he'd offered to turn himself in?
Determinations of how to make arrests under arrest warrants are made based by the tactical operators in the district. They are not.
But you surely looked into it by this point, right? You know the answer, surely.
All I know is what the FBI has said, which is that they made decisions on the ground as to what was safest and easiest. So they do not agree with your description of what happened on the scene.
You don't agree with my description. I'm pointing out what the photo is. There are agents here who have long guns and ballistic shields. Let's take a look at the hardened criminals that your Justice Department sent these armed agents to go terrorize on that morning. Here they are. Here they are at Mass. Here's the 7 children with Mr. Houck and his wife. In this early morning, they were all at home. Mrs. Houck has said repeatedly the children were screaming. They feared for their lives. You got these agents demanding that he come out. They've got the guns, she said, pointing at the house and at them. He has offered to turn himself in. And this is who you go to terrorize. What's really interesting to me is this seems to directly contradict your own memorandum about the use of force at the Justice Department. You say officers may use only the force that is objectively reasonable to effectively control an incident. Are you telling me that in your opinion as Attorney General, it was objectively necessary to use 20 or 30 SWAT-style agents with long guns and ballistic shields for these people?
What I'm saying is that decisions about how to go about this were made on the ground by FBI agents.
So you're saying you don't know?
I'm saying what I just said.
Which is that you're abdicating responsibility?
I'm not abdicating responsibility.
Then give me the answer. Do you think, in your opinion, you are the Attorney General of the United States, you are in charge of the Justice Department, and yes, sir, you are responsible. So give me an answer.
The FBI does not agree with your description.
I'm not asking about the FBI. You are the Attorney General. Give me your answer. Do you think that it was objectively reasonable and they followed your guidelines in sending 20 to 30 armed agents to terrorize these people? Yes or no?
The facts I have, which are those presented by the FBI, are not consistent with your description.
So you think it was reasonable?
I'm saying the facts are not as you describe.
What, that the children weren't there? That there weren't long guns there? That there weren't agents? What do you dispute? What's the factual premise you dispute? Be
FBI
specific.
said they don't agree with your description of...
Be specific. They don't agree with what?
Of how many agents, of the agents who were there, and of what their roles were. They don't agree.
Do you know the
That's all I can
jury
say.
in this case acquitted Mr. Houck? As I'm sure you're aware. Do you know how long it took him?
I am aware, and we respect the decision of the jury.
Do you know how long it took him?
I don't know.
1 hour. 1 hour. Philadelphia District Attorney declines to prosecute. The private suit's dismissed. You use an unbelievable show of force with guns that I just note liberals usually decry. We're supposed to hate long guns and assault-style weapons. You're happy to deploy them against Catholics and innocent children. Happy to. And then you haul him into court and a jury acquits him in 1 hour. I just suggest to you that that is a disgraceful performance by your Justice Department and a disgraceful use of resources. I notice a pattern, though. The FBI field office in Richmond on the 23rd of January of this year issued a memorandum in which they advocated for, and I quote, the exploration of new avenues for tripwire and source development against traditionalist Catholics, it's their language, including those who favor the Latin Mass. Attorney General, are you cultivating sources and spies in Latin Mass parishes and other Catholic parishes around the country?
No, the Justice Department does not do that. It does not do investigations based on religion. I saw the document you have.
What did you do about it?
It's appalling. It's appalling. I'm in complete agreement with you. I understand that the FBI has withdrawn it, and it's now looking into how this could ever have happened.
How did it happen?
That's what they're looking into. But I'm totally in agreement with you. That document is appalling.
I'll tell you how it happened. This memorandum, which is supposed to be intelligent, cites extensively the Southern Poverty Law Center, which goes on to identify all of these different Catholics as being part of hate groups. Is this how the FBI, under your direction and leadership, is this how they do their intelligence work? They look at left-wing advocacy groups to target Catholics? Is this what's going on? I mean, clearly it is. How is this happening?
The FBI is not targeting Catholics, and as I've said, this is an inappropriate memorandum, and it doesn't reflect the methods that the FBI is supposed to be using. It should not be relying on any single organization without doing its own work.
Let me just ask you, as my time expires here, a very direct question. How many informants do you have in Catholic churches across America?
I don't know, and I don't believe we have any informants aimed at Catholic churches. We have a rule against investigations based on First Amendment activity, and Catholic churches are obviously First Amendment activity.
Well,
but I don't know a specific answer to your question.
You don't know the specifics of anything, it seems, but apparently on your watch, this Justice Department is targeting Catholics, targeting people of faith, specifically for their faith views. And Mr. Attorney General, I'll just say to you, it's a disgrace.
Senator Cotton.
Mr. Attorney General, I want to return to the illegal protest outside of Supreme Court justices' homes last summer. It's plainly unlawful to protest outside of a judge's home to influence the outcome of a pending case. You testified earlier that as far as you know, no charges have been brought against those protesters, but you never really explained why. Why have no charges been brought against those protesters?
The decision about making arrests is left to the marshals on scene. Their principal...
Marshals are law enforcement officials. They're not prosecutors. I did not say arrests. I said charges. These people were not criminal masterminds. They posted videos of themselves on their social media accounts. They advertised the protest in advance. It is possible to arrest someone for an offense after the offense has occurred, has it not?
It is, and
why did you not send anyone to arrest those protesters in the days after the protests?
We're allocating our resources towards protecting the lives of the justices and their families. Decisions have to be made on the ground as to what is the best way to protect those lives.
Mr. Attorney General, do you not think that it would perhaps provide a deterrent effect if you arrested some of these criminal protesters and charged them and threw them in federal prison?
We are trying to protect the lives of the justices. That is our principal priority. I'm leaving it to the Marshal Service to make determinations on the ground. They have to make determinations about what they see on the ground.
Look, consider the efforts your department has put into tracking down everyone who was even on the Capitol grounds on January 6, 2021. You've dedicated millions of man-hours to study videotape, to do forensic analysis of computers and devices, to go knock and conduct interviews. You can't allocate just a few agents to look at people's social media accounts and say they were present outside of a justice's home, we're going to go arrest them and charge them. It's a black letter violation of the law.
Our priority is violence and threats of violence and protection of the lives of the justices, and that is what we're doing.
Again, these are not criminal masterminds. They posted pictures and videos of themselves protesting. You could probably go arrest one today from a cold start. Why can't you do that?
I'm saying again, our purpose is to protect the lives and safety of the justices. That's how we're allocating resources.
You sent the FBI, as several senators pointed out, to do an early morning raid on Mark Houck's home in front of his children for the grave crime of singing hymns and saying prayers outside of an abortion clinic, charges of which he was acquitted by a jury of his peers within an hour. You can't send the FBI to track down anybody who is protesting outside the home of a Supreme Court justice?
And I want to be clear, our purpose here is to protect the lives and safety of the justices.
I think
that's why we're doing that.
The answer is that you are sympathetic to the protesters, that you didn't like the decision the justices were about to issue. I think we all know what you would do if a bunch of conservative protesters were outside the home of a Democratic appointed justice to the Supreme Court.
No one has ever been arrested under that
statute. It's a
statute
simple black
under those
letter legal
circumstances.
violation. You will not send a single agent to conduct a single arrest and charge them on something that they have zero defense for. It's because you're sympathetic to left-wing protesters.
Thank you, Mr. Chairman. And Mr. Attorney General, I want to go back to what... Thank you, Mr. Chairman. And Mr. Attorney General, I want to go back to what we discussed earlier with the 2 tiers of justice. And the answers you've given us, you're very subjective in how you approach decisions. You don't seem to be rules-based in how you make these decisions. As a matter of fact, you come across as being very political in the decisions that you make. And politicizing your work is something that really offends most Tennesseans. But I want to ask you about this 2 tiers of justice, particularly in the way you've responded to congressional oversight investigations. The House Judiciary Committee recently requested that you turn over documents relating to the special counsel investigation of President Biden's mishandling of classified documents. But your DOJ so far has stonewalled the House request, claiming you can't turn over documents on an open matter. Now let's compare that with your decision, obviously very subjective, to fully cooperate with document request from the House January 6th committee. Your FBI had no problem at all turning over documents and information to that committee, even though they related to an open investigation. Do you see this comparison here? Do you appreciate this? This is a prime example of 2 tiers of justice, your 2-tier system, who you're going to cooperate with and who you are not. So why have you cooperated with the document requests that were made from Democratic-led committees, but you have refused, Chairman Jordan, and you have refused the House Judiciary Committee when they are requesting documents that pertain to President Biden's mishandling of classified documents?
So we greatly respect the oversight responsibilities of the committees of the Congress. And at the same time, we have to protect our ongoing investigations. I do not believe we turned over information to the January 6th committee about ongoing investigations.
Your responses, you give one set of responses for Republicans, another for Democrats. You have one tier of justice for people that are conservatives and another for those that are on the left. You told me earlier that you didn't know who Jane's Revenge is. They are all over Twitter. I'm going to do you a favor. I am going to send you a letter with a whole lot of Twitter and different feeds to help you in that investigation for the Hope Clinic.
Thank you, Senator Blackburn. Senator Coons, Senator Cotton.
Mr. Attorney General, I want to explore the dangerous crisis at our southern border and your role in causing that crisis. Asylum traditionally is reserved for people who face things like religious persecution, persecution for their political beliefs, or violence because of their race or ethnicity. In June of 2021, you changed the department's asylum rules so that it could apply to individuals with significant gang violence in their home country. Is that 2021 interpretation still in place?
It is. It reinstates a previous interpretation that the department had had of the same asylum rules, yes.
Okay. Do you know the most recent murder rate in Honduras?
I'm sure it's enormously high.
It's 36 per 100,000 people. What about Colombia?
I don't know.
23 per 100,000. Guatemala?
Again, I don't know, but I believe it's quite high.
17 per 100,000. What about Mexico, right across our southern border?
I also think it's very high.
28 per 100,000. So I have to say, since you rewrote the rules of asylum based on the perceived degree of violence in these countries, I'm a little surprised you didn't know those, but let's look a little bit closer to home. Do you know the murder rate in New Orleans last year?
I don't, but I want to be clear, this wasn't based on violence. This is based on threats specifically to individuals, on gangs, where the country was unable to protect the person. That's what it was about. It wasn't about violence in general.
Well, okay, well, you're partly responsible for protecting Americans, so let's see. Honduras' government can protect its own people except for 36 out of every 100,000 for murders. Guatemala, 17 out of every 100,000. The murder rate in New Orleans last year was 70 for every 100,000. What about St. Louis?
Again, it's very high, I think.
68 per 100,000. What about Baltimore?
Also very high.
58 per 100,000. Should American citizens in places like New Orleans and Baltimore and St. Louis begin to seek asylum in countries like Honduras and Guatemala under your asylum principles?
Look, again, I'm saying that the principle here is protection of specific individuals who are being threatened by the gang and where the local country is unwilling or unable to protect them.
So is the United States government and the city governments of St. Louis and Baltimore and New Orleans unwilling or unable to protect its own citizens?
I don't believe they're unwilling. They're doing everything that they can. We're supporting them in every way they can. The examples you're talking about are ones where they are unwilling to protect from gangs.
So, Mr. Attorney General, one of the reasons we have a crisis at our border where we have illegal aliens running to our Border Patrol, not away from our Border Patrol, is this interpretation of asylum. That anyone, anywhere who lives in a dangerous or poor country can come here and seek asylum, as opposed to seeking it, as is traditionally the case, for things like persecution on religious belief or political practice. But let's move on. Let's move on, Mr. Attorney General.
But that's not the standard. I want to be clear.
I want to come back to a question that Senator Cornyn started. Your unprecedented memo in December of 2020 to direct your prosecutors not to pursue the most serious, readily provable offense. I have gotten numerous contacts in my office from your prosecutors who are shocked that you have overturned this decades-long bipartisan standard. You said this was about allocating resources. What resources are you talking about?
No prosecutor was directed to not bring a case again. In fact,
your memo specifically says that if they feel that it's not warranted, or only if the other offenses are not sufficient, they should not pursue what has been the standard for decades, generations of U.S. attorneys and their assistants.
I'm well aware of the standard because I helped write the standard originally.
Because it was a Carter administration standard, not specifically known for being tough on crime.
Well, it was the first time the principles of prosecution were reduced to a book which explained what they were. It was included in it. Every assistant U.S. attorney is able to use their discretion to bring these kinds of cases. No one's being directed to not do anything.
You specifically said that they should not pursue the most serious, readily provable offenses in cases where mandatory minimums are present because it's not warranted. You specifically said that.
But I said...
What does mandatory mean?
I'm trying to say that...
Does it mean that prosecutors get a choice not to pursue it if we write the law in that way?
The memorandum said that cases of violent crime, which is specifically what you're asking me, are ones where, in fact, it's most likely that they should be bringing the highest and mandatory minimums.
Is it your assertion here that drug trafficking is not a violent crime?
No,
it's built on an entire foundation and edifice of violence.
Yes, and it includes an exception in the same memorandum we're talking about for significant drug trafficking as well as for violent crime. That's right.
Let's get your specific answer. I wrote it down here. I was so surprised by it. You said to Senator Cornyn, this is about allocating resources. Yeah. What resources are we allocating? If one of your assistant U.S. attorneys has some criminal lowlife who could be charged with 12 offenses, but they don't charge the 2 most serious readily provable offenses because of your memorandum. They're still charged with 10 offenses. They have to go to a grand jury. They have to go to trial. They have to have a pre-sentencing report. They have to have a sentencing hearing. How is that conserving resources that you don't charge them with the most serious readily provable offenses that would lock these lowlifes up for the longest time possible?
The lowlifes that you're worried about and have expressed worried about, the large drug traffickers, the violent criminals, they are to be charged to the max.
I ask again, what resources were you talking about? You said to Senator Cornyn specifically it was about allocating resources. What resources?
These include our investigators and how much we have to investigate in order to establish the requirements for mandatory minimums. The prosecutors have to prove those cases, the judges who have to try those cases, and the jails that have to hold those cases, those individuals for longer terms.
Jails are, I don't see how jails could be a problem. You only have 158,000 prisoners now. 10 years ago, it was 219,000. Do you need more prisons?
Well, I think that...
Kenny's an appropriator. I bet he could get you more prisons.
I think many of the senators have complained that the jails are too filled, that they're overcrowded, that we're not able to provide the level of protection and security for guards and for prisoners that we would like. But that is not what this is about. Again, I want to be clear. The memorandum was crystal clear that they are to charge the most serious provable offense in cases involving violent crime and drug trafficking.
Okay, let's turn to another example of you overriding Congress's will. Congress has repeatedly decided to impose stiffer penalties for crack cocaine than powder cocaine, done originally at the request of members of the Congressional Black Caucus, voted for by senators like Senator Durbin, the chairman of this committee. 10 years ago, they made change to that. They specifically kept the ratio higher, and they didn't make it retroactive. Now, you have directed your prosecutors, when they are dealing with crack cocaine, to charge it as if it was powder cocaine, something that this Congress has repeatedly refused to do, which we refused to do as recently as December when Senator Booker tried it on the floor and I blocked it. How do you explain overriding Congress's decision on this distinction between crack and powder cocaine to suit your own policy preferences?
The long-standing rule is that the Department of Justice uses its discretion in which charges to bring, regardless of which ones are available, which ones are to bring. Every bit of evidence we have is that there's no difference between powder and crack. Governor Hutchinson testified to that fact.
Those are legislative decisions. Those are not prosecutorial decisions. If this Congress wants to do it, maybe it will one day, and maybe I'll be outvoted. But those are legislative decisions. Those are not prosecutorial decisions. You said at your confirmation hearing that you had to follow the law as it was written, that the executive branch could not rewrite the law. What you were doing is rewriting the law. It's not a single prosecutor out on the front lines making one decision. You're directing every federal prosecutor to override the law that has been written by Congress.
We're using our discretion as to which charges to bring, in which circumstances, which ones are appropriate. That's what we're doing. That's a long-standing history of prosecutorial discretion in the United States.
Senator Hirono?
Thank you, Mr. Chairman. Mr. Attorney General, hello.
Oh, yeah, and our allies as well, yes.
Senator Cornyn?
General Garland, I'm sure you will agree with me that the independence of the federal judiciary is one of the crown jewels of our form of government. And historically, federal judges have had a hard time defending themselves against attacks of various kinds. And I just want to raise with you my concerns that we're seeing not only attacks like those from former staffers of this committee who happen to now be on the outside, and special interest groups, saying that now when reporters cover the story of cases being decided by a judge, they ought to cite the partisan affiliation of that judge. And saying it's important to say, for example, it's not just Chief Justice Roberts, or say that he's a Republican, not a conservative-leaning justice. This is happening in the press. It's happening on social media. As you've already discussed with some of my colleagues, this has led to political protests at the justices' homes and even a threatened assassination of a member of the Supreme Court of the United States. But unfortunately, it's not just limited to the outside partisan rabble-rousers. It includes speeches made by United States senators on the floor of the Senate Mr. Chairman, I'd ask unanimous consent that a copy of this speech dated February 16th be made a part of the record.
Without objection.
This is a speech by a United States Senator trying to discredit a judge, happens to be in Texas, Matthew Kacsmaryk, that Senator Cruz and I recommended and who was appointed and now serves with lifetime tenure as a federal judge, calling him a lifelong right-wing activist, a partisan ideologue, an anti-abortion zealot. And he goes further to say that regardless of how Judge Kacsmaryk may decide this particular case, that it will inevitably be affirmed by the activist Fifth Circuit Court of Appeals, and then surely rubber stamped by the United States Supreme Court. I find this sort of rhetoric, particularly by a United States Senator, to be appalling, and I wonder if you will join me in condemning that sort of attack on the independence of the federal judiciary.
When I first got on the judiciary, I and several of my colleagues pounded our heads against the wall trying to get the reporters to stop, and this is more than 25 years ago, to stop reporting the name of the president who appointed us and or the party. Unfortunately, this is a battle that has not been won, and I don't think, obviously, given the authority of the First Amendment and its importance, is one that we're not going to be able to win. I come from a kinder and gentler era, and a kinder and gentler court, even in terms of the way the members of the court treat themselves.
General Garland, you
I
are
don't know what else to
the
say.
Chief Law Enforcement Officer of the United States.
Yeah.
Will you condemn it?
I am against divisive rhetoric of all kinds, but I do not have authority in this matter. As you know, the speech and debate clause.
You have moral authority.
My moral authority is against divisiveness from all sides and all quarters, and from all arguments to be made on the merits. That is my moral authority.
Senator Lee.
Durbin, who has gone to vote, I'm going to call on.
You're blaming it on Durbin, huh? I understand. I apologize for going over.
I take full responsibility.
Thank you, General.
Senator.
Thank you, Senator Kennedy, for the grace. And thank you very much for being here. I just want to confirm, because I've heard some misstatements. Fentanyl is permanently scheduled at Schedule 2, correct?
Yes, the discussion is about fentanyl analogs.
So let's go to fentanyl analogs. Fentanyl analogs are scheduled now at Schedule 1. They are not expiring this year. Fentanyl analogs are Schedule 2, the expiration date for which is at the end of 2024, correct?
It might be the fiscal year. I'm not sure exactly.
But it's in the year, it's not 2023, it's at the end of the year 2024.
Yeah,
fiscal or not?
I'm not exactly sure of the time. I know that there's short time on this, and we believe it should be re-upped.
Okay. I want to jump into the executive order from President Biden on policing. It took really important steps to ensure that federal law enforcement agencies are engaging the best practices to make themselves and the public safer. Some of these policies the department has adopted and is making great progress on, including limitations on chokeholds, guidelines for no-knock warrants, which is extraordinarily dangerous for police officers themselves, and a cleaner standard for the use of deadly force. Even the Trump EO, though, included the need for us to have a database that is, I guess, called an accountability database to serve as a repository for officer misconduct records within the next 8 months, which is now this past January. Trump's executive order, which was issued in June of 2020, also directed the Attorney General to create such a database to collect this information. What's the status now on that?
Yeah, there's a working group run by the Deputy Attorney General to stand this up. As you can imagine, there are difficulties with respect to getting reporting and also difficulties with respect to defining what a determination has been made. But we are seized with this, and we are working full speed ahead to get this done.
I'm grateful and hope we can continue to communicate on that. It's invaluable. And the EO directed you to encourage state and local agencies to contribute to the database. How's that going?
Yeah, we have made outreach to all the major law enforcement organizations who support this proposition. We are making outreach to state and local law enforcement. We are making progress. I can't really say more than that at this point, not because I don't want to say, but because I don't know.
Okay. The Biden administration, in cooperation with the Congress, acting in a bipartisan manner, has put significant amounts of money into the COPS grant program. In fact, I think under the last Congress, it was one of the highest amounts of money given to programs that help local police departments. Really proud that President Biden did that. I'm just curious what processes are in place to ensure that the funds are being used for intended purposes. Does the department audit those grants?
Yeah, whenever a government agency gives out grants, there's always a risk, and so we have very tight auditing and review processes for these grants.
And do you have the resources you need to adequately audit the grants in your estimation, or is that something that Congress might act to give you the more resources?
I'm going to say again to you what I've said before. Whenever anybody wants to offer me more resources, I'm happy to have them. But I think we're capable of doing what the Congress wanted us to do with the resources we have right now.
I appreciate that wise response. In December of 2021, you said the department would exercise its discretion to ensure that people released on home confinement under the CARES Act would not unnecessarily return to prison. My experience, I've been visiting prisons since I was a law student, and I usually go in and ask wardens, who are often tough men and women who really are about the protection of their officers, the community at large, and I always ask, are there people here that are a waste of taxpayer money? And they will often tell me stories about elderly folks, infirmed folks. But here now we had a pandemic, as you know, and there was a release program with really high standards to meet for anyone being released. And I appreciated your comments on this matter in the past. I just want to ask, can you confirm that the department will not revoke individuals released under the CARES Act for minor violations? We always know there's so-called status violations where somebody might cross a county line or do something that is a technical violation, which is often minor. They're not a threat to public safety. Can you confirm again that the department will not revoke individuals that are released under the CARES Act for these so-called status violations once the public health emergency expires?
Yeah, so just to give the full context, the CARES Act allowed us to put people in home confinement who we ordinarily would not have been able to do because of the length of time remaining on their sentence. The question was raised whether those people would have to go back after the expiration, which is now going to be in May, I believe. The Office of Legal Counsel, interpreting the statute, found that they would not have to go back, that all that was necessary was that the Attorney General put them into home confinement. When I say the Attorney General, I mean the Justice Department and the Bureau of Prisons, and that they could remain subject to what the normal rules are on having to go back. So if somebody commits the kind of violations that would normally require somebody to go back to prison from home confinement, those would apply, but no special rules to people who came under the CARES Act. And let me also say, in support of what you said, there's now been enough time to have statistical data on recidivism, has found that the people out on the CARES Act, the number of serious crimes committed is extremely tiny and not of concern.
All right. On July 16th, my last question, my penultimate question. On July 16th, 2022, you said that the Justice Department is examining marijuana policy and will be addressing the issue in the days ahead. And in October of 2022, President Biden urged an expeditious review of the schedule of cannabis and directed individuals federally incarcerated for cannabis possession be expunged. What is the current state of the review of cannabis at the Justice Department, and when can we expect policy changes on this important issue?
I think everything that you said is correct. The president commuted sentences, and this is still working its way through the system to get the final certificates of commutation, but that is accomplished. The HHS is working on the question of scientific analysis of marijuana. Within the department, we are still working on a marijuana policy for the department. I have to say that the crack powder thing came first in my list of things that had to be done first, but that was accomplished, as you already know. And I think that it's fair to expect what I said at my confirmation hearing with respect to marijuana policy, that it will be very close to what was done in the Cole memorandum, Deputy Attorney General Cole in the Obama administration. But we're not quite done with that yet.
Well, I'm very eager to get to hear more about that, and I'm hoping that you can give that review. The complicated policies as more and more states, red and blue, are moving. It'd be good to hear that as quickly as possible. And I just would like you to respond for the record. There's some scurrilous statements out there that you're dissatisfied with your chief of staff and would like him to be replaced by his eldest son. So if you could respond on the record for me at some point about that.
The only bad mark in his resume is that he worked for you once, so.
Thank you, sir.
Senator Blackburn.
Thank you, Mr. Chairman, and Mr. Attorney General, thank you for your time today. Listening to the questions and the answers and your responses, what is coming clear to me as I listen to this is basically in
Senator Collins and I are returning this committee to regular order, and I couldn't ask for two better members to help steer this committee through, so thank you for the work you're doing to get that done. I think we all realize we have a responsibility to get these funding bills done in a timely bipartisan way that really makes sure our country and our communities have the resources they need to keep people safe. It is no small task, and so I'm glad to have both of you partners in getting this done. And as I think this discussion today makes clear, keeping our families safe doesn't just mean having a strong military. Obviously, that's important, but it also means having a fair, functioning system of justice and safe communities. We can't keep our families safe from threats like drug trafficking that is bringing the deadly fentanyl in, or white supremacy and the uptick in hate crimes, without investing in effective law enforcement. And as we saw yesterday with the devastating shooting in Nashville, I think it's all too clear we have to do more to protect our kids and our families and our communities from gun violence, which will require us to, of course, do more to strengthen our laws, but it also requires the resources we need to carry out the laws we already have on the books and keep guns away from violent criminals. And you know, we have made some progress to support state red flag laws to protect survivors of domestic abuse. We have to do a lot better for women, and that includes in our indigenous communities where so many violent crimes against women have gone unsolved. This is something I'm really focused on, making sure that this unacceptable injustice on tribal lands is met with strong work from our country now. And of course, we can't forget that we aren't protecting our families unless we're also supporting the Civil Rights Division in fighting against bigotry and discrimination. And we can't keep our democracy a democracy if we're not protecting Americans' most basic rights, the right to use your voice, the right to vote, and I also clearly mean the right for women in every corner of our country to get the health care and family planning services that they need. So these are really important challenges, and to meet them, we need strong investments in the critical work of this subcommittee. So we've got a lot of work ahead of that. So Attorney General Garland, thank you for being here. I do have a few questions. One of them on your budget was I was really glad to see an increase in the Office for Violence Against Women. I have long advocated for improvements in VAWA grants, including the special tribal criminal jurisdiction, so Indigenous women and children and survivors can seek justice in our courts. I also authored and got signed into law legislation to make sure survivors of sexual assault can get medical exams when they need to be able to seek justice. So I wanted to ask you today, can you walk me through what your proposed budget does for investments in these critical areas?
Right, so for the Office of Violence Against Women, we're asking for $1 billion, which is a $300 million increase over the previous enacted appropriation. This includes what you just mentioned, $20 million in a new program for access to sexual assault nurse exams. It includes $147 million for reducing the DNA backlog for rape kits. This includes both Violence Against Women Act and Office of Justice Programs funds. Collecting DNA, forensic research, training, testing, includes money for the Debbie Smith DNA Backlog Grant Program. Then it includes $300 million, which is a $45 million increase in grants to combat violence against women, the so-called STOP Act. $100 million for sexual assault services, which is a $21.5 million increase. That's for rape centers and for non-governmental organizations that provide crisis intervention and victim assistance. There's a legal assistance program of $95 million, which is a $40 million increase for civil legal aid for domestic violence and sexual assault victims and survivors. Transitional housing for victims, $95 million, which is a $45 million increase. I mean, there are many more aspects of the program, but those are big numbers.
I really appreciate that, and I appreciate the focus on that, and I think those are critical investments that we need to really strongly consider in this committee. Senator Moran asked you about fentanyl from sort of policy perspective. Can I ask you, since this is something we're all concerned about, what is in the president's budget to address the opioid crisis?
Yeah, so obviously there's two sides of this, as you correctly said. One side is the law enforcement side, and the other is our effort to deal with opioid addiction and abuse, and to make people whole and to help them survive. On the law enforcement side, we're asking for $10.4 billion, which is a $342.8 million increase for all of our law enforcement. So this includes DEA, both for its law enforcement agents and for diversion control, which has been a serious problem, obviously, with respect to the opioids. Marshal Service, the FBI, which includes particular targeting of fentanyl and opioid trafficking on the dark web. Our Office of, or our Organized Crime and Drug Enforcement Task Force, OCDF, $550.5 million for their strike forces. The Criminal Division and the Civil Division, both of which provide law enforcement on both the criminal and the civil side. And then grants for the Bureau of Justice Assistance and the cops for anti-heroin and anti-meth. And for the healthcare and fraud and abuse control, so we have both the Appalachian regional opioid task force and the New England regional task force. And we're asking for money for both of those.
Okay, and my time is out, but I'll just say this to this committee as well, that we all want to make sure that we're doing everything we can with the opioid crisis. We need to have a strong budget capability to invest in these programs. They are a critical part of dealing with this crisis. Thank you.
Thank you, Senator Murray. Senator Collins.
Thank you, Madam Chair. Mr. Attorney General, thank you.
Thank you, Senator Collins. Senator Schatz.
Thank you, Chair. Attorney General, thank you for being here. I want to start with the enforcement of the Prison Rape Elimination Act. There was a recent report from the Bureau of Justice Statistics that showed more than 2,000 incidents of sexual harassment and misconduct by corrections staff in federal facilities. What is the department doing to ensure that the Bureau of Prisons, corrections officers, and other staff members are taught from day one how to address and, more importantly, prevent PREA violations?
PREA is an extremely important act, and I know you had an important role in getting it passed. As you know, we have a new director of the Bureau of Prisons, and she has committed herself to focusing on this problem like a laser. She's establishing new training programs in this area. Our Deputy Attorney General has set up a working group to go over all the problems that have been discovered in a series of our own U.S. Attorney's Office and Inspector General investigations to solve, to work on these problems. As you know, all the Bureau of Prisons facilities are audited every 3 years under PREA, and we get reports every year, so that's how we know about these problems. But accountability is obviously another important factor here, and As I'm sure you know, last week, on March 22nd, the former warden at FCI Dublin was sentenced to 70 months for multiple convictions involving sexual abusive conduct. And we have a quite aggressive effort to root out those who are committing criminal acts in abuse of their positions of authority. So it's a combination of increasing the training, increasing the surveillance, and then increasing the punishment.
Thank you. Hawaii, as you know, has not had a federal halfway house since October of 2019. Since then, I've included report language in the CJS appropriations bill asking for an update. I have not received an update. Do you have one for me?
Yeah, so I share your frustration over this problem of not being able to get a residential reentry center in Hawaii. And we do clearly need to find a way to solve this problem. We have a team at BOP that has been particularly tasked on this question. As you know, there have been multiple solicitations for residential reentry in Hawaii, which have not been successful. This team is planning a trip to Hawaii in the near future to talk with stakeholders about what the problem is. Obviously, an important part of the problem has to do with real estate and zoning issues in Hawaii. But we can't wait until we get that. So at the same time, we are working on sort of almost workaround solutions. And one of those is to award a contract for a day reporting center in Hawaii. And we are hopeful that we are close to being able to do that. We've closed the solicitation on that. And we're hopeful we'll be able to do that. Now, that does not meet the need for residential reentry, but it's one thing that we can do in the meantime. I'm grateful for your concern about this. This is certainly pushing us on this. And I'd offer when the Bureau of Prison team goes out to Hawaii, if you want to meet with them either before or after, I think it would be useful from both points of view.
Please, thank you. Let's talk a little bit about President Biden's executive order on police reform. We've had some statutory changes as well as some executive orders around the 1033 and 1122 program. My specific question is, when the department finds that state and local law enforcement agencies have engaged in a pattern of civil rights violations, what process does it follow to ensure that transferred equipment is returned to the federal government?
So as you know, the President's executive order prohibits transfers of certain military-type equipment to law enforcement agencies. Our own law enforcement agencies are in compliance, and from FY22, onward, the Office of Justice Program grants have restrictions that prohibit the purchase or transfer of the list of prohibited military-type equipment. From what I understand, we have not yet encountered a situation where equipment had to be returned under a pattern or practice finding. The EO provides that if there is a pattern or practice finding for newly transferred equipment, it would have to be returned. We made these restrictions clear to the law enforcement agencies in our grants, but we do not yet have a circumstance where it's been required.
Is there a regular period of oversight or audits, or is a pattern practice finding something that just happens episodically on a sort of a case-by-case basis?
Yeah, I think the pattern of practice investigations, as you no doubt you remember, we just opened one in Louisville. We just, in the last few days, mostly resolved an older one in Seattle. We have them in a number of other locations, but they are not routinely done across the country. They are where there's evidence to provide a credible concern about pattern or practice with respect to a particular law enforcement agency.
Thank you.
Thank you, Senator Schatz. Senator Kennedy.
Thank you, Madam Chair. Thank you, General, for being here. General, I want to ask you about the shooting at Covenant.
Thank you, Senator Schatz. Senator Kennedy.
Thank you, Madam Chair. Thank you, General, for being here. General, I want to ask you about the shooting at Covenant School, which is part of the Covenant Presbyterian Church. I realize that the shooter is dead, but the shooter could have had collaborators do you plan on opening a hate crime investigation for the targeting of Christians?
The FBI and ATF are both on the scene, working with the local police. As of now, motive hasn't been identified, and the police chief said at his last press conference that they don't yet have reached a conclusion with respect to motive. We are certainly working full-time with them to try and determine what the motive is, and of course, motive is what determines whether it's a hate crime or not.
Okay.